There's no fixed formula for dividing assets after separation, but there is a structure and it matters more than you might realize. I'm John Boy, Principal Solicitor at JB Solicitors. I've been working for over 17 years in family law and commercial litigation. I also act as a nationally accredited mediator and arbitrator. In that time, I've worked with everything from amicable splits to multi-jurisdictional disputes involving companies, trusts, and property pools that spread across continents. In family law, the court follows a 4-step framework to decide what's fair. If you understand that, you stop guessing and you make better decisions early. So in the next few minutes, I'll walk you through the 4-step framework the court uses to determine how your assets should be divided, the mistakes that cost people thousands, and how you can position yourself early even before lawyers get involved. Let's start by clearing up a common confusion. When most people think of getting divorced, they assume the paperwork to end the marriage also includes splitting up the finances. But under Australian law, that's not how it works. They are actually 2 separate legal processes. The first is the divorce order. That's the court document that legally ends the marriage. You can only apply for it once you've been separated for at least 12 months. The second is the property settlement. This is the process where your assets and liabilities are formally divided. But this part doesn't have to wait for the divorce order to be granted. You can begin negotiating and formalizing the division of property from the day you separate. In fact, it's often better to start early because the law uses the current value of the assets at the time of the agreement, not the value at the time of separation. So if you delay sorting it out and your partner's investments go up, or property value rises, or new debts get added to the pool, it can affect what you're entitled to. Which brings me to the next thing people often ask. A common question I get is, can we agree on a 50-50 split over coffee and leave it at that? Technically, you can. But if that agreement is not formalized, it is not legally binding. In some circumstances, that means either party can come back in 5, 10, or even 20 years and ask for more if a court hasn't signed off on the deal. Also, keep in mind that the court assesses asset values at the date of the agreement, not the date of separation. I've seen cases where someone accepted a payout years ago, but later reopened the matter after a property boom. So if you're relying on a verbal agreement or assuming things are final just because they felt fair at the time, you could be leaving the door open to future claims. The safer part is to formalize the agreement properly, either through a consent order or a binding financial agreement. More on this later. With either of these agreements, both parties know where they stand, and neither side can revisit the arrangement years down the track. But before you can do any of that, you need a full picture of what's on the table. This is called the property pool. It includes everything owned by either person, both in Australia and overseas. That means homes, investment properties, superannuation, shares, crypto, tools, businesses, even debts like tax and HECS. Everything gets listed, and full disclosure is not optional. If someone hides an asset, the court can impose penalties or adjust the division against them. Now, if you're going down the path of a consent order, this next part is essential because it's the framework the court will use to decide your agreement is fair. But even if you're opting for a binding financial agreement, it's still worth understanding this structure. Lawyers often use the same approach behind the scenes to guide negotiations because it reflects how a court would assess the split if the matter ever ended up there. This is the 4-step structure every lawyer and judge follows. Step 1 is to calculate the net property pool. That means assets minus liabilities as of today. Step 2 is to assess each person's contributions. That includes financial contributions, homemaker contributions, and non-financial inputs like running a business, unpaid, or managing renovations. Step 3 looks at future needs. The court considers health, age, income capacity, who's caring for the children, and whether any adjustments are needed to reflect that. Step 4 is a final sense check. Is the outcome just and equitable? Let me give you an example. Let's say we have a couple who's ending a 20-year marriage. They have 2 children, both under 12. One partner, let's say the mother, has been the primary carer for most of the children's lives. The father has worked full-time and earns a significantly higher income. They own a family home, 2 cars, some superannuation, and a small investment property. Here's how the court might work through the 4 steps. Step 1 is identifying the pool. That would include the family home, both cars, both super accounts, the investment property, and any debts, like the mortgage and credit cards. All of that gets added together to form the net asset pool. Step 2 is assessing contributions. The father may have made the larger financial contribution through income, while the mother contributed more in non-financial ways, raising the children, running the household, and supporting his ability to work those hours. In a long marriage like this, courts often view contributions as roughly equal. Step 3 is looking at the future needs. The mother has lower income earning capacity and will likely continue to carry the bulk of the day-to-day care for the children. She may need more financial support to maintain housing, manage childcare, and re-enter the workforce part-time. That could justify an adjustment in her favour. So even if contributions are considered 50-50, the court may adjust the split to 60-40 in favour of the wife based on her future needs. Step 4 is the final check. Is the outcome fair given the whole picture? If the answer is yes, then that's the basis for the proposed division. Once you've worked through the 4-step test, you still need to lock it in. Australian law gives you exactly 3 ways to formalise your property settlement. Option 1, consent orders. This is a mutual agreement signed by both parties and reviewed by a registrar to ensure it's fair. Option 2 is a binding financial agreement. This is more flexible and doesn't go to court, but both sides must get independent legal advice. Option 3, court orders. This applies when there's no agreement or if safety, disclosure, or fairness is in doubt. Each path suits a different situation, but whichever option you choose, there are time limits you need to be aware of. If you are in a de facto relationship, you have 2 years from separation to file a property claim. If you are married, the deadline is 1 year from the date your divorce becomes final. So if you separate and do not apply for divorce, that time limit has not started. It does not matter how long you have been apart. Unless the divorce is granted by the court, the 1 year countdown does not begin. In practice, this means a person can be separated for many years, but still be legally vulnerable to a property claim later on because the divorce was never formalized. This is why it's important to understand the distinction between emotional separation and legal divorce. The law is tied to the official process, not the personal timeline. Understanding the legal timelines is one part of managing a separation properly. The other part is how you act during the process. In my experience, many of the clients who face complications later on made avoidable mistakes early. These decisions might have seemed minor at the time, but they often come up in legal proceedings and can affect the final outcome. Clients who struggle often made one of these mistakes early on. They said or texted something in anger, which was later used in court documents. It can be hard to think clearly in the middle of a separation when written communication can end up being submitted as evidence. Once it's on record, it can be difficult to explain or take back. They signed property transfer forms, loan documents, or bank paper without getting proper advice. In some cases, this was done to keep the peace or move things along. But without legal review, these documents can have unintended consequences that are hard to undo. They also moved or hid assets, often thinking it would give them more control or protection. But once financial disclosure is required, those actions are usually uncovered. Courts take a strong view on attempts to conceal or shift money, and it can affect both credibility and outcome. These are not rare mistakes. They tend to happen when people try to move too quickly without advice or when they assume things will stay amicable. Even in cooperative separations, clear steps and proper process make a difference. Which leads me to the question, can you divide assets yourself or do you need a lawyer? If the asset pool is small, both sides are transparent, and the agreement is straightforward, a self-drafted consent order may be enough. But if there are business assets, superannuation splits, overseas property, or family violence involved, get legal advice early. To give you a rough sense of cost, a simple consent order might cost a few $1,000s. A contested matter going to court could cost over $30,000 per person. Every separation looks different, and there's no single path that fits everyone. But the more clearly you understand the structure, the timelines, and your responsibilities, the better place you are to make informed decisions. If you're working through a separation now and feel unsure about where to start or how to formalize things properly, it can be helpful to speak with someone who understands both the legal process and the practical realities. I've left a link in the bio below if you would like to get in touch with someone from our team. Otherwise, if you want to know more about the divorce process, I have a step-by-step breakdown that you can check out. Cheers.